So we've just heard from the Minister giving us, I guess, the policy perspective on charity regulation 10 years on. And now we have an opportunity to hear about a regulator's perspective, looking at what charity regulation has been like. A little bit of a policy and sector look as well. And then going outside Australia to New Zealand, we'll be looking at thoughts from New Zealand on their process and perhaps what that might mean for Australia. So I might introduce each of our, I'll introduce our first speaker, Anna Longley, who's the Assistant Commissioner General Counsel at the Australian Charities and Not-for-Profits Commission. We had a wonderful day at the Regulators' Day yesterday, which got us all asking lots of questions and thinking pretty hard about charity regulation. And now we're very lucky that Anna has, I don't know if she's had any rest since getting the Regulators' Day ready and then coming here, but she's very happily for us agreed to come and talk to us today. So we're very grateful. Prior to her role at the ACNC, Anna was an Assistant Commissioner at the Australian Tax Office and led audit and assurance teams there, and has also sat on the ATO's General Anti-Avoidance Rules Panel and gained significant experience with administrative law, dispute resolution and litigation. So she's very well placed for her role at the ACNC. Anna, I'll hand over to you, and I'll just, you just press the button here, you're on speaker, or you can use the lectern, whichever you prefer.
I might stand.
Okay.
Didn't push the button. That's the one thing public servants are supposed to be good at, right? Oh dear, maybe I'm not well placed. Thank you very much for having me. There have been some acknowledgements of country earlier, so I won't repeat those. I wrote something for this last night, and then I woke up this morning and I scrapped it all and I didn't like it. And I thought, what on earth am I going to talk about to this amazing group of people? There's a lot I can talk about though. I wanted to touch on the achievements, I think, from the last 10 years. I wanted to touch on what I see the role of a regulator as being. And I also want to touch on, I think, some of the opportunities that we have, because I think there are plenty. And you've just heard from the Assistant Minister, and some of what he said, I've really just busily taking notes up the back. You know, I think anything that makes it easier for the sector is fabulous, because guess what? It makes it easier for the ACNC as well. A lot of, you know, I think a lot of the points of angst and difference are not necessarily based in the regulator as such, but possibly in the regulation and in the laws that we have. So the opportunity that we have to influence that, I think, is a really good one. I think probably the biggest achievement of the last 10 years actually is the establishment of the ACNC. That did take a lot of work in getting it up. It was a very long process. I was clearly not involved in any of it, but I do think it was fantastic for the sector. Also along with that is the establishment of the charity register. I think it's a really useful tool. And I think also with the enhancements to the charity register that have been made, there's some real opportunities there that I think we will start to see over the next few years in terms of the use to which some of those searches can be put, and the way that we can find charities based on programs, based on locations, based on beneficiaries. So I really hope that in the next few years we can start to give some feedback as to maybe what some of those benefits of the enhancements have been. I think also bringing together the data sets and publicising them and combining them through our Australian Charities Report, as well as the data we have on data.gov.au, is really good. It allows us to see a picture of the sector that hadn't been seen in that way previously. Also the streamlined reporting arrangements and the work that we do to share information through the charity passport. I've also been learning recently about the data scheme that's been set up, and so there's potentially further opportunities for us there to share that data. Sharing of data is really useful, particularly in the sense of trying to make sure that we have charities that have to report less often to less regulators or other organisations, and the Assistant Minister raised that as well. The review of the ACNC legislation, I think, was fantastic, and we've managed to implement some of those recommendations. Clearly, again, you've heard the Assistant Minister say there's some other thoughts there around recommendations that were made and haven't been implemented, and I guess we'll wait to see what the government's approach is on that. We have a continued focus on trying to improve our guidance, our processes and our policies. Yesterday's launch of our e-learning modules, I think, was a really good step in that. And so we'll be doing some more communications next week about that. For those who weren't at the Regulators' Day, we have launched what is currently 8, but will be 12 free online e-learning modules that are aimed at generally directors or soon-to-be directors of small charities, although we do think it will be useful across the board. Also, we are reviewing the entities on the register. Part of that is through the government-funded review of charities with DGR endorsement, and part of that is us looking at some of the charities that may have some risk factors. Now, I know that there have been some issues with the way that has been rolled out. Sally addressed some of those yesterday at the Regulators' Day. As I said, we are committed to continual improvement, and that's an area where we said, yep, we didn't quite get that right. We're making a change. And I think really that's all we could do. We can't go back. But we can commit to make changes, and we can commit to working with the sector, and that is really what I think is so important. I wanted to touch on a point also that several regulators made yesterday, which was the role, they were talking about the role of a regulator as having to balance the supportive aspect of their regulated community, in this instance charities, with the regulatory requirements that exist. We have to balance the views of the sector, which are extremely important, with expectations of government, the legislation that we have, the regulatory framework within which we operate, and also the expectations of the community more broadly. And we work under 3 principles under the Commonwealth framework currently: continuous improvement and building trust, being risk-based and data-driven, and engaging in collaboration and engagement. I think we've got opportunities in all of those areas. And I think we have a perfect coming together of circumstances in the current phase that we can look to build on some of those opportunities and really look to how we are engaging with the sector, how we are engaging with the broader community, and how we can make sure we do it better. I do want to note, however, the separation of powers means we don't make the law. We can't change the law. We have to operate within it. And the ways that law is changed is through Parliament and also through judicial decisions. Now, I know there's a whole thing there about funding judicial decisions. It's probably not something that I could go into here. It also doesn't change the fact that I still can't change the law, even though there may be barriers to charities progressing some of that law change. So I do acknowledge that, and I do think it's an important consideration, one that I turn my mind to frequently. The other thing that I won't raise, that has been raised this morning, is the potential constitutional issues. It will send me into an existential crisis. Do I even exist? I don't know. It makes it very difficult. So I have to pretend that everything's fine, because that's what we have to assume. Because the laws are put in place, we have to assume that they operate as they're intended to. So I also wanted to just acknowledge, as I said, that there's much that we can do. I'm hoping we can overcome what I would consider a bit of air of distrust. I want to work with the sector. I think that's really important, and I think we have those opportunities to do so. We will have differences of opinion. I think it's quite reasonable to have differences of opinion. Within the sector, there are differences of opinion, and I think it's about how we engage with those differences, and I think it's about how we debate them, either to agree, which would be fabulous, or I think also importantly, pinpoint where is it that we disagree? Where is it that we think we need change, or that we think we need some further clarification? You know, I have said over the last almost 3 years that I've been here, feel free to call me. I think I'm going to change that message. I think it is, please call me. I'm sounding a bit like Jennifer Moltisanti yesterday, who was asking for likes on her LinkedIn. Please call me. If there are issues, call me. We've probably been thinking about them as well, quite frankly. And you may not have seen all the work that we're doing in the background. That's it from me. Thanks.
So what, we might hold questions over to the till all of our three presenters have presented. No. So our next presenter, Christian Siebert, holds a joint appointment as an industry fellow Christian Siebert holds a joint appointment as an industry fellow at the Centre for Social Impact at Swinburne University, and a policy and regulatory specialist at Philanthropy Australia, as part of a partnership between the two organisations. I think many of you already know he was previously an advisor to the former Assistant Treasurer David Bradbury, during which the ACNC regime was created and the Charities Act passed. So Christian's very well placed to talk to us from a policy and sector perspective about regulation 10 years on. Christian.
Thanks, Ian, and really interesting remarks, Anna, and thanks for the invitation to be here today. ABL actually have a special place in my journey. Don't worry, I'm not going to get too deep. I remember when I was a second-year student at Deakin University, and I was in a property law class, and Peter Seidel actually came and spoke to us about the Yorta Yorta case at the time, and I still remember it because I was so touched by it, and it was something at the time because of our colonial education system that I'd not been exposed to much. And what I learned then and what I learned this morning was really significant. And I also want to acknowledge the traditional owners of the land on which we are here today, the Wurundjeri people of the Kulin Nation, and pay my respects to their elders past, present and emerging, and Indigenous Australians that are here with us, First Nations Australians that are here with us today. And something that I do grapple with is that we talk about charity and regulation and philanthropy. I'm teaching a unit in philanthropy this semester at Swinburne, and it is all very much from the lens of Europe. The Statute of Elizabeth in the early 1600s, when the traditions of altruism, reciprocity that exist outside of the European and colonial context date back to tens of thousands of years in Australia, and I want to pay tribute and acknowledge that. So yes, it is 10 years, nearly 10 years since the ACNC was established or created. So the ACNC bills, there was two bills, the Main Act and the Consequential and Miscellaneous Amendments Act, or Bill at the time, great name. They passed both houses on the 1st of November 2012. So the ACNC was initially meant to start up at the 1st of July 2012, we pushed that back to September, then we couldn't make that. So we then just said, okay, we'll pass the bills, and then we'll just tell the Governor General when to assent to them, and that will be when the ACNC starts. So a really nice, neat process. I don't know if you've heard the quote by the former leader of Germany prior to World War I, Otto von Bismarck, where he said that making policy or making law is like making sausages. You only want to see what comes out at the end. You don't want to see what goes into that process. Although I'm Polish, so I actually do quite enjoy watching what goes into that process as well as what comes out at the end. It did pass on the 1st of November, passed the Senate. There were lots of amendments made in the Senate, then it went back to the House to be ticked off in the House. And I suppose I want to say at the outset that it was a really exciting, exhilarating moment, especially for a sort of then 29-year-old with a bit more hair up there, less hair down here, because I thought you shouldn't have a beard when you're wearing a suit. That's changed. Well, I don't wear suits either. That's changed as well since then. But it was a product of so many people contributing to it. The Treasury officials, the work of Susan, David Murray and others at the ACNC task force, and all of you, the people who campaigned for this over so many years, who shaped what the ACNC became, and it's not perfect. There is room for improvement in terms of the legislative framework and other aspects of it, but it was really a collaborative effort. And I do still remember when David Bradbury was promoted to Assistant Treasurer and I was his acting Chief of Staff, and meeting with Anne and Linda Lavarch in David's wood-panelled, very John Howard-esque Sydney office to talk about this. And I didn't know that much about it. I'd studied regulatory policy at the London School of Economics, but I didn't know much about charities regulation. That was going to change, and I didn't expect that to change as much as it did. But it was a really fantastic collaborative effort, and it was wonderful when the ACNC actually did commence on the 3rd of December 2012, when the Governor-General signed the bills to give them royal assent, and then the launch event was on the 10th of December. The royal assent on the 3rd of December, and the launch event was on the 10th of December at Charcoal Lane, a social enterprise run by Mission Australia. And it was a great event, and still have some photos from that. And I think it's important to recognise that it may not have actually happened. A lot of it was actually touch and go. There was a whole suite of reforms in that era that just didn't happen. They were too hard. They couldn't get through the Parliament. They were shelved. That was always a possibility. And then, of course, the ACNC could have been abolished when there was a change of government, and it didn't happen. And pleasing to say, it's part of the furniture now, and a lot of what the debate is about is what colour is that furniture? Do we get it reupholstered? What kind of polish do we use for the furniture? But it is a part of the furniture, and I don't say that in a bad way. I say that in a great way. It's a really pleasing outcome that it is a part of our institutional architecture in Australia more broadly and within the charity sector. And yeah, the debate is really about the direction of the framework, not about its existence anymore. Constitutional questions aside, because it's just convenient to be able to say that. But in terms of some of the reflections over the last 10 years or approaching the last 10 years, and Anna touched on this tension that regulators have between, especially the ACNC, because of the objects, especially objects 1 and the tension between objects 2 and 3. The tension between support and compliance. There is a bit of an existential, and again, don't worry, I'm not going to get all Albert Camus on you, but there is a bit of an existential quandary that the ACNC finds itself in compared to other regulators, because it wouldn't exist if there wasn't something to regulate, some sort of risk to manage. But at the same time, it is also there to support the sector very clearly as set out in Object 2. So how you reconcile those objects is a challenge. And I do have a piece today in Pro Bono Australian News as part of their Dear Commissioner series of columns that different sector representatives and experts are writing sort of letters to whoever the new commissioner is, and the ad just went up earlier today. Actually, I might have tweeted it and put it on LinkedIn because I'm so digitally savvy. But there is this tension, and my piece for Pro Bono Australian News touches on that. And I think a lot of the debate does come down to approach or culture of the regulator. And I think it's hard to legislate that. You can add factors that the commissioner needs to consider and feel good about that and put more detail in an explanatory memorandum, all of that. But so much of the regulatory framework, the ACNC regulatory framework, and a lot of others too, depend on judgment, discretion, interpretation. It's not just what's in the Act or the regulation. And of course, the ACNC doesn't, or the commissioner doesn't make the law, but they do apply it. And there's a lot that comes down to judgment, discretion, interpretation, how the commissioner, how the regulator approaches engagement, how it looks at how far we can go based on what the common law says or not, where we can land. There's all sorts of things that really come down to, the practice versus just what's in the Act or in the regulations. And I don't think we can put too much weight on what's in the Act or the regulations. It's important, or what's in the common law, or what a court says. There's a lot of weight there, but a lot of it also comes down to people and the decisions, the choices of people, the words they use, the way they engage. And I really like engaging with the ACNC and really rate working with Anna and the team. And over many years, there's been lots of changes, but I think it's, I really enjoy it. But yeah, there can be disagreements, there can be different views, but how those work through, again, they come down to how people interact and engage. And it's okay to also have disagreements. There's nothing wrong with that. But I think my point here is that looking back on some of these, say, tensions, challenges, how do we shape the culture and the approach to make some of this easier, knowing that we can't just legislate everything. We can't just take things to the courts or the AAT and that'll solve the questions. Imagine getting a judge to sort of talk about culture and how long that judgment would be. And I think because of that tension, the ACNC is really unique because of those objects that it's got compared to other regulators. And I do think that we probably going forward, the Assistant Minister touched on, the vision for the ACNC, for the sector, touched on the ACNC review, and Matthew is here, one of the panellists of the ACNC review. And I think that we do need to look at or revisit the question of governance of the regulator, and there were some recommendations in the ACNC review about that, having an executive committee that runs the regulator and formalising that. Because the ACNC, it is a bit unusual in that a lot of regulators such as ACCC, ASIC, the Tax Practitioners Board, TPB, the power is vested in a board or a number of commissioners. Some regulators like say the ATO, which is a regulator, or ORIC, they have a single statutory officer that has power vested in them, statutory power vested in them. But I do think that we need to open it up and look at, well, should we have an ACNC commissioner or commissioners or a board with a commissioner subject to the oversight of the board, how we formalise that, what the relationship would be, etc. And we can look at things such as the OECD best practice principles on regulator governance that set out the different governance structures and organisational models. Because I think that at the moment there's a lot of power vested in one individual, which is different to a lot of other regulators, even the Tax Practitioners Board, which is in the same portfolio. The ATO does vest a lot of power in one individual, but it's a much bigger organisation. There's a lot of other scrutiny mechanisms there. I think that looking at the governance structure of the ACNC going forward as part of other reforms and initiatives has certain benefits. And I think spreading some statutory power within the regulatory framework has benefits in terms of, less reliance on what one person decides, and it addresses the risk of politicisation. We want to have a merits-based recruitment process for the next commissioner, and we will, but we can't always be sure that that will be the case. So it distributes power, statutory power, provides some horizontal accountability between those individuals in which statutory power is vested, draws in expertise and experience from different people, from the sector, from government, from other regulators. But it can also address other related issues, like we talked about, sort of, development of the law and the costs associated with taking things to court, etc. Well, if you had a board or something like that, of a board like the Tax Practitioners Board or a board like the ACCC or ASIC, well, you create another avenue of internal appeal as well, which could help facilitate the development of the law. So I'm really just putting that out there as looking at some of the reflecting on the last 10 years and the tension that exists there between the different roles of the ACNC and some of the tensions that exist in terms of how the ACNC works. And it's okay for there to be tensions, but I think it's useful for us to reflect on them and what we can do to manage those tensions. And I think, that there are various options. I mean, I'll conclude by just saying that one option could be to have say, a ACNC board. The advisory board becomes a board, has, say, 4 to 6 part-time members, and the ACNC commissioner on it as well. And it's responsible for setting policy practice, examining sort of appeals, at least sort of in the first instance, handling sensitive or complex decisions. And yet, authority is delegated for most matters, most work, to the ACNC commissioner, who is a full-time appointment, and they run the ACNC. That wouldn't be too different to a lot of other regulators. And I do think that it would help solve a lot of the problems, tensions and challenges that we've got. And I think it's something worth looking at. And it's prompted, by reflecting on the past 10 years. But just, to end on a high note, I think it's really worthwhile remembering that a lot's changed in 10 years. But we still have an ACNC, and we're going to have an ACNC for a long time, I think, and that may not have happened. And the reason it's happened is thanks to you and many others. And the reason it's still here is thanks to you and many others. And hopefully together we can work to shape its future and, have a really positive future in that regard. Thank you.
Thank you so much, Christian. I might hand over now to Sue Barker. Sue is the director of Sue Barker Charities Law, a boutique law firm based in Wellington, New Zealand. And she's a member of the Charities Services Sector Group and the Core Reference Group for the Review of the Charities Act. For the last 2 years, many of the people in the room know that Sue's been on sabbatical at the New Zealand Law Foundation as the International Research Fellow, undertaking research into the question, what does a world-leading framework of charities law look like? So Sue's promised she's not going to take us through the full answer to that question today, because she has released, and we'll put a link up to a report that pretty comprehensively addresses that question. And so Sue, I'll hand over to you to talk to us. Thank you.
Thank you, Ian. Can you hear me okay?
Yes.
Awesome. Thank you. Tēnā koutou katoa. Hello, everyone. It is my pleasure to be here today to share some reflections on the last 10 years from a trans-Tasman perspective. One of the things that has struck me the most over the last decade, and Christian spoke to this, is how well the Australian charitable sector seems able to come together and speak up on its own behalf, and also how well it seems to be supported in doing so by a critical mass of specialist lawyers, academics, accountants, and others. Australia, of course, does have the advantage of scale in comparison to New Zealand. Our entire population is broadly equivalent to that of the city of Melbourne. But my impression, nevertheless, is that Australia does get much better charities law as a result of the level of consultation and engagement. One example of this, in my view, is how well Australia did in getting enshrined into the legislation the second purpose of the ACNC Act, to support and sustain a robust, vibrant, independent and innovative not-for-profit sector. I know there have been issues with how to progress this purpose and how to measure it, but the key point in my view is that it is there, sitting like a silent sentinel, watching over decision-making under the Act. The second purpose has particular significance in my view in relation to the first purpose of the Australian legislation, to maintain, protect and enhance public trust and confidence in the Australian not-for-profit sector. Like Australia, New Zealand also has a purpose to promote public trust and confidence, but it is important to note that the antipodes are unusual in this regard. In most comparable jurisdictions, the phrase public trust and confidence is used in relation to the functions of the agency responsible for administering charities legislation. In other words, it is used as an accountability mechanism to confine the powers of the government agency and enable its performance to be measured against a clear objective. New Zealand originally followed this trend. The original Charities Bill that was introduced into Parliament in 2004 provided for the Charities Commission to have a function of making appropriate information available to the public to promote public confidence in charities. The sector envisaged that the Charities Commission would be able to use the data it was gathering by means of the Charities Register to proactively respond in an evidence-based and balanced way to any negative publicity about charities, thereby enabling a more balanced public perception of the charitable sector. An additional function of promoting the effective use of charitable resources was then added at the last minute at Select Committee stage in 2004. However, the difficulty began for New Zealand when these two functions were elevated to purposes of the overall Act, when the Charities Commission was controversially disestablished almost exactly 10 years ago in July 2012. It is not clear why these functions were elevated to purposes. The ACNC bill was passing through the parliamentary process at the time, and perhaps New Zealand was emboldened by Australia's inclusion of a public trust and confidence purpose. Another theory is that perhaps it was done to enable these two functions to apply to both charity services and the Charities Registration Board in the unusual bipartite structure that was created when the Charities Commission was disestablished. Whatever the reason, in the rush to pass the legislation, no consideration appears to have been given as to the implications of elevating these functions into purposes, particularly in the context of disestablishing an independent agency and transferring its functions to a business unit within a government department. Intuitively, promoting public trust and confidence does not make sense as a purpose of the Act. It is not an end in itself. We do not promote public trust and confidence in charities for its own sake or so that levels of public trust and confidence might be admired. Promoting public trust and confidence in charities is arguably merely a means to a deeper goal of maximising the ability of charities to provide benefit for society. This, in my view, highlights the real significance of the second object of the ACNC legislation. It provides context and arguably moderation to the first object. But the difficulty for New Zealand is that there is no equivalent. Without any legislative articulation of such a deeper goal, New Zealand's purpose of promoting public trust and confidence, particularly when combined with New Zealand's purpose to promote the effective use of charitable resources, becomes weaponised against charities. As John Tyler would say, it threatens to morph into overreaching exercises of governmental power in the name of enhancing trust and confidence. Charities in New Zealand are being turned into pale imitations of government as underfunded service delivery arms of government. New Zealand arguably now has the most restrictive charities law framework in the common law world, in application, if not in legislation. Because what might promote public trust and confidence is open to interpretation, and a decision appears to have been made in New Zealand that promoting public trust and confidence in charities requires heavy-handed regulation and ever-increasing restriction over what charities can do and what charities can say. The net result, in my view, is that New Zealand charities law is slipping off its jurisprudential moorings. This can be seen in cases such as New Zealand Computer Society, Canterbury Development Corporation, Queenstown Lakes Community Housing Trust, Redraco, as well as the recent Supreme Court decision, in my view, respectfully, and Family First, all of which are fundamentally inconsistent with Australian authority. I very much doubt that such cases would be decided the same way if they came before a court in Australia. On that basis, I would respectfully argue that Australia should exercise considerable caution before applying these cases in practice in Australia. A related difficulty is the New Zealand appeal mechanism. Australia, like most comparable jurisdictions, allows charities to access an oral hearing of evidence, which allows charities a fair chance of testing any material that might have been found from the internet in searches conducted by the agency deciding whether a charity is eligible for registration or not. In my view, the significance of this issue cannot be overstated. Dr. Gary Johns said yesterday that advocates often express different concerns to those expressed by charities themselves. And charities are such reluctant litigants by nature that I imagine the appeal mechanism might be an example of such an issue. Charities might rationally put it to one side, thinking it will never apply to them. The problem is that for those charities in New Zealand that have appealed, they have encountered a process that unduly favours the original decision maker. Whether a purpose operates for the public benefit is a question of fact. Facts are determined by evidence. Evidence should have the opportunity to be tested according to established rules of evidence before an independent judicial adjudicator. The inability of New Zealand charities to do this causes the appeals process to be tainted by adverse and untested findings of fact made by the original decision maker from their internet searches. This is another factor that should be borne in mind when evaluating the applicability of New Zealand charities law jurisprudence in Australia, in my view. Australia also has the advantage of having reviewed its definition of charitable purpose and setting out the test for whether a purpose is charitable, including the important public benefit test, in its legislation. Having such clear guardrails reduces the ability for subjectivity and discretion in assessing whether any particular charity is eligible for registration. Another difficulty in New Zealand is that when the Charities Commission was disestablished, all of the accountability mechanisms provided by the Crown Entities Act were correspondingly removed, but they were not replaced with anything. Charity services are subject to almost no meaningful accountability beyond minimal passing reference in a 200-page Department of Internal Affairs annual report. Most comparable jurisdictions require the government agency responsible for charities to report to Parliament. Anna Longley mentioned yesterday that the ACNC was in the process of preparing its corporate plan. New Zealand Charities have no corresponding ability to meaningfully question charity services on its strategic direction or its performance against any plan. And although the Charities Registration Board has been made nominally responsible for registration decision-making and is not subject to direction from the Minister, sadly the Board is not sufficiently independent of charity services to be able to exercise the independent check on decision-making that was originally intended by the 2012 reforms. The net result is that registration decisions are effectively made or very heavily influenced by a business unit of a government department. This structurally undermines the independence of charities and therefore that which makes them distinctive and valuable. As Greenpeace noted in its 2019 submission, if the executive branch can control civil society institutions via the charities registration process, then we don't really live in a democracy. Further, the current arrangements apparently deprive the charitable sector in New Zealand of an agency able to speak up on its behalf. As a business unit within DIA, Charity Services appears unable to speak up for charities in the way the Charities Commission was originally intended to do. The effect of this was seen after the mosque shootings in Christchurch in 2019, when a high-profile charity was overwhelmed with unexpected millions in donations. The inevitable delay in distributing the funds to victims led to trenchant and very unfair criticism of the charity online. But neither Charity Services nor the Board took steps to reassure the public that the charity was doing its best in extraordinary circumstances and that distributions would follow in due course, as did, in fact, transpire. By contrast, when similar issues arose following the 2020 bushfires in Australia, the ACNC Commissioner was able to speak up on behalf of the affected charities, reassure the public that the charities had acted appropriately, and thereby minimise damage to public trust and confidence. Another difficulty is that the business unit in New Zealand is housed in the Department of Internal Affairs. In addition to administering the Charities Act, the DIA oversees approximately $650 million of grants and other funding. A large number of registered charities in New Zealand, including umbrella bodies, receive funding from the DIA. The resulting conflict of interest apparently leaves the charitable sector in New Zealand bereft of anyone to speak up for it unless towing the official DIA line. New Zealand charities now appear to be suffering from Stockholm Syndrome. Another example of Australia getting better law, in my view, is the foresight Australia had in enshrining the requirement to carry out a post-implementation review of the legislation after 5 years in the legislation itself. Such a review was duly carried out by a panel that was independent of the ACNC. I appreciate that a number of the recommendations have not yet been actioned, but the Minister made some positive comments, I thought, in that regard. But by contrast, after almost 20 years, New Zealand is still waiting for a proper post-implementation review of the Charities Act. A review of the Act was announced in 2019, but sadly, its terms of reference were highly attenuated and excluded most issues of concern for the charitable sector, including the definition of charitable purpose and agency structure. To make matters worse, responsibility for carrying out the review was given to the DIA, resulting in the DIA effectively being tasked with reviewing itself. Last month, the Minister for the Community and Voluntary Sector in New Zealand announced proposed changes to the Charities Act resulting from this review process. The Department of Internal Affairs' own regulatory impact statement speaks of the inadequate problem definition, inadequate consultation, and a lack of evidence to support the proposals. Sadly, the Minister's proposed changes are unlikely to do anything to benefit New Zealand's communities, despite the rhetoric otherwise, and are more likely to act perversely to preclude the real issues from being addressed. The appointment of the new Minister in Australia has been very encouraging. New Zealand has the opportunity to be world-leading in designing its charities law framework. If the Minister is still listening at any stage and has the chance to have a word with his counterpart in New Zealand, please could you talk about social capital? The New Zealand government has stated objectives regarding social cohesion, well-being, enabling social enterprise, etc., but appears to have entirely overlooked the important role of the charitable sector in these regards, as evidenced, for example, by the proposals that have just been announced. So I would like to say well done to Australia for having the foresight and wherewithal to articulate the second object, for articulating the test for whether a purpose is charitable in legislation, for legislating a review, and for managing to hang on to the ACNC as an independent agency. And I look forward to gaining further inspiration and hope from Australia over the next 10 years. Thank you.
Thank you so much, Sue. It's not often that Australia is held up as a progressive beacon in comparison with New Zealand, so we'll take those compliments. Thank you. Now, we've got morning tea in a moment, but I think we do have time for one or two quick questions if anyone has them. We've got Marla and then Murray. And Jess, are there any questions online?
Thank you so much. That was all really interesting. And I particularly, Christian, when you were talking about culture, something that occurred to me is when I started at the ACNC shortly after it was established, and a lot of the people who worked there were from the sector. And there was then a hiring freeze. And because of the relationship with the ATO, the staff often had to come from the ATO, and certainly it's much easier to move staff across from the ATO. Now, the ATO obviously has a very different mandate. It's often quite compliance focused, and there's also this overlay of protecting the revenue, which is quite different to what the ACNC is supposed to do. And I wonder whether some of the cultural issues that some people might have identified could have come from that shift at the ACNC, and whether we should be looking at trying to decouple the ACNC from the ATO to help with that culture change.
Good question, and I don't want to sort of speculate too much, but I suppose from a high level sort of framing of a response, I think that a regulator that has the objects that the ACNC Act has in it, I think from the very outset needs to have a mix of people that reflect those objects and the achievement of those objects, and all three of them are equally important. One's not more important than two or three. Two or three aren't more important than one. They're all equally important, like the 3 or 4 leaf clover story, but I won't get into theology. Murray will get that. But they're all equally important. So you need a mix of people that can deliver on that. And I think that that's balanced against the fact that the ACNC is there to achieve those objects, but there is object one, and there is a risk of regulatory capture if people were just drawn from the sector. And sometimes the ACNC won't always be able to be the friend of all charities. There will be disagreements and action will need to be taken. So I think there needs to be a good balance. I don't know sort of whether that balance is right now, and I think that it's something that the new commissioner, whoever that may be, really does need to consider. I do think that a lot of it does come down to the leadership and the policy environment and the context, and that's not something that the ACNC controls. There's been a change in the context in the last few months with a change of government, and I would actually say as well that the ATO, I think, really does try its best and really does engage really well. Jennifer, Louise Clark and I'm co-chair of the NFP Stewardship Group within the ATO with Louise Clark. And I think that's evidence of the fact that people can come from backgrounds where they've worked in the ATO for a long time or worked somewhere else, etc. But where they're really serious about their work and what they want to achieve, good things can happen. That doesn't mean that you don't need the right mix of people from different backgrounds. I think there's evidence in lots of different spheres about the benefits of diversity, different perspectives, etc. But I think that, yeah, it's going to be an interesting and complex question for the new commission to consider. I sort of touch on it a bit in my pro bono Australian news column that might be live now or a bit later. And I didn't actually plan that. It was just a product of my own disorganisation that it worked out. But it's coming online just after I gave my talk. Thank you.
And Anna, do you want to comment, or is it a bit unfair to ask you to comment on that question?
No, I'll be fine.
Right, well, I know there are more questions, but I think we've got time just for one from Murray, and then we might break for morning tea. And there's a microphone coming your way.
Anna, thanks for your enthusiastic engagement and willingness to be open to the inquiries of the sector and advisors and academics. You mentioned that the law develops through judicial decisions, and the Federal Court has made it clear that a charity that is dissatisfied with an ACNC decision should first go to the AAT and request a judicial member. So could you comment on the ACNC view on the precedential value of the AAT and whether the ACNC will follow the guidance of the AAT?
Yes, thank you. So you've actually just inadvertently taken Angela's question to me later. Now I've got nothing to talk about. We do, we've got lots. So I think the case that you're probably referring to is Australians for Indigenous constitutional recognition. And my take on that was not so much that charities should go to the AAT first, but in terms of the cost consequences, then the AAT is a no-cost jurisdiction and they do have the opportunity to seek a judicial member. So I think that's important because the Federal Court is quite a legitimate pathway for a charity to take following an objection decision. Putting aside, of course, the very important cost considerations, I don't want to downplay that, but I guess I'm talking about process possibility versus how in practice it might work. So the AAT sits within the executive branch of government. It doesn't sit within the judiciary, and I think that is it's important for the administrative law nerds to spend a lot of time thinking about. But the AAT, therefore, is a really good guide. It's a really good guide for the ACNC and any other regulators in understanding how it is that decisions might be made or because the AAT thinks about the correct or preferable decision. And so it gives us a really good guide as to how we could be thinking about cases. And so the other important fact is that it is a merits review. So it looks at the merits of a case, it reviews the facts of the case and will often make factual findings. And so where a decision is made that relies on specific factual findings, we will apply that. We'll apply we'll apply that decision to similar factual scenarios, most definitely. We also think about, well, where does that get us to in terms of what like factual scenarios actually, what does that mean, and which are like cases. In terms of anything that the tribunal might say, particularly in obiter around what the law is, that's not a finding that the AAT, that we make in terms of the precedential view of that. And so there are opportunities, I think, to test the law still. Again, there's still the funding issue. But, I think we want to test where the law is, but at the same time take into account what the findings of the AAT are. Of course we do. We've made decisions already that rely on the findings in Global Citizen to register charities. We've done that already.
Thank you. Now, I can see morning tea has arrived. So I think what we should do is if you have further questions, if you hold them over, and you can always catch our panellists at morning tea, but if you can just join me in thanking our three panellists again.